Good morning. This is your Kelso Report for Wednesday, January 18th, and I'm your host, Clark Kelso. We have only 3 Ninth Circuit cases today, our first one dealing with issue preclusion. The policy behind principles of claim and issue preclusion is that a litigant should have only one opportunity to litigate. The Ninth Circuit applied the principle of issue preclusion in White v. City of Pasadena to prevent the plaintiff from relitigating her wrongful termination claims in federal court after having lost the same claims in state administrative proceedings which had been affirmed by state courts in administrative review proceedings. Now, applying California's law on issue preclusion, the Ninth Circuit held that when state administrative findings rejected the plaintiff's argument that she had been terminated based on her perceived disability, and those findings were affirmed by the California courts in a writ of administrative mandamus under 1094.5, those findings became final and precluded the plaintiff from raising and relitigating the exact same factual allegations, the exact same issue, in a Section 1983 action in federal court. Litigation must come to an end, and the plaintiff had already litigated and lost. Next, criminal law. Some days, it just seems like everything goes wrong. Better off staying home. And that is what happened to the prosecution in United States versus Kuwak, where the defendant got caught up in a federal sting involving the defendant's efforts to export certain defense articles, even though the defendant did not have an appropriate license for such exports. The defendant was charged with 4 counts. First, attempting to export defense articles without a license. Second, purchasing defense items with knowledge they were intended for illegal export. Third, conspiracy to do the first 2. And fourth, money laundering related to the first 2. Now, the defendant had admitted the conduct, basically, but claimed duress based on threats by a foreign government to his family. A defense which the trial court held after opening arguments the defendant could not present because of insufficient evidence. The defendant was convicted on all 4 counts. So far, so good. But on appeal, it all fell apart, and the Ninth Circuit reversed. First, the court held there was no jurisdiction to charge money laundering because the applicable federal statute required laundering of more than $10,000, and the amount laundered was only half of that. So the laundering count went away. Second, noting that there is no general federal attempt statute, the court held that the statute which criminalized exporting defense articles without a license did not contain an attempt provision. So the defendant could not be charged with attempting to export or attempting to cause another to export the defense articles. There just was no such federal crime. On the remaining 2 charges, the trial court had erred in refusing to permit the defendant to present evidence of duress. So the conviction on all 4 counts were reversed, and the case remanded for a new trial. Definitely not a good day for the prosecution. Finally, in the area of immigration law, the immigration laws require that the Citizenship and Immigration Service adjudicate a petition to remove conditions on an alien's conditional permanent residence status within 90 days of the interview. The purpose of this requirement was to ensure prompt adjudication. But in Chettiar v. Holder, the Ninth Circuit held that the statutory language, quote, within 90 days of the interview, close quote, had to be interpreted flexibly, so that the 90-day clock was not triggered when the Citizenship and Immigration Service scheduled its initial interview with the petitioner, an initial interview which clearly contemplated a subsequent interview. According to the court, the 90 days was triggered only at the conclusion of the scheduled interview process, since it was not rational to interpret the statute as imposing a jurisdictional requirement that the decision come within 90 days with the first interview scheduled between the service and the petitioner. So the court holds the 90-day clock did not run. That changes the decisions made by the lower courts, and they have to remand it. That's it for today's Kelso Report. Have a great day in the law.